Hello my friends, Thomas with Alpha Concepts here. This is the fourth in the 5-part series about the use of force in Illinois. In this episode, we're specifically going to be talking about civil immunity and how that's a double-edged sword. We're going to be talking about how that applies to defense of person, defense of dwelling, and defense of other property. I hope that you checked out the first 3 videos, use of force in defense of person, dwelling, and other property. Again, this is the 4th in the series, and there's one more episode to follow, which is going to be the 5 rules of self-defense. So right now, let's talk about civil immunity in Illinois.
This video is sponsored by Alpha Concepts Firearm Training. Alpha Concepts offers firearm training for beginners or the advanced shooter. Sign up for a concealed carry training class today and learn from the best in Chicago. Check the training calendar at alphaconcepts.com or call 847-612-3952.
In the previous videos, we discussed the justified use of force exonerations of defense of person, dwelling, and other property. Each one of those has a civil immunity clause. And I'm not a lawyer, but just paraphrasing, it says basically that if your use of force that was justified, what we previously discussed, if your use of force was justified, then you can't be sued either by the aggressor, the attacker, or their estate, should they have lost their life while you were defending yourself. So, having said that, it seems great on the surface, but I've said a few times that it's a double-edged sword. First, let's take a look at word for word specifically what the civil immunity has to say, and then I'll explain why I believe it to be a double-edged sword. Illinois law says, in no case shall any act involving the use of force justified under this section give rise to any claim or liability brought by or on behalf of any person who is acting within the definition of aggressor set forth in section 7-4 of this article, or the estate, the spouse, or other family member of such a person, against the person or estate of the person using such justified force, unless the use of force was willful or wanton misconduct. So again, in my layman interpretation, it says that if your use of force was justified, you can't be sued, and that sounds great. The problem is, who proves justification? Who determines justification? Well, ultimately on an affirmative defense, it is your responsibility. You are guilty until proven innocent. You have to prove your justification. Who determines justification? That's ultimately on the judge and the jury. So in my layman interpretation, what this actually does say is if you have gone to court and if a judge and a jury says not guilty, then you can't be sued. That's my interpretation. Let's say the prosecutor says, hey, we're not going to file any charges. This was a clear-cut case of self-defense. Then the question becomes, are you justified or not in your actions? Well, you might feel justified. The prosecutor felt you were justified. But as I just said, prosecutors don't determine justification. Ultimately, it's the judge and the jury who determine the justification. So you are still open up to civil litigation. You still now have to prove your justification in civil court if someone were to sue you. Let's look at a real-life example of this. And this actually goes a step further. Kyle Rittenhouse. Now, Wisconsin law has a similar use of force justification to Illinois law. He was found not guilty, and he is still being sued. So we see that you can be sued for anything. The letter of the law, what the words are, as well as previous case law, becomes your defense in court. This clause, this civil immunity, gives your lawyer something to argue about in court. So ultimately, remember, you are guilty until proven innocent. And an affirmative defense shifts the burden of proof to you. You have to prove your justification. And if that's not done in criminal court, that might be done in civil court. The letter of the law becomes your defense. It gives you something, it gives your lawyer something to argue about on your behalf. But ultimately, you have to prove your justification, and that's why the civil immunity is a double-edged sword. Again, in my opinion, or my layman opinion, what this says is if you're found not guilty, you can't be sued. We look at the Rittenhouse case, and obviously, again, anyone can be sued for any reason at any time. So we have to always understand the potential ramifications of a self-defense situation, and I'm always talking about the 5 aftermaths of a self-defense situation, and this is civil is one of them that we need to be prepared for. As always, my friends, be armed, be trained, and be alpha.